Thank you, SCL India, for providing me with this wonderful opportunity of providing case law review before these esteemed panelists and audience. I'm presenting my review on a very important, very interesting judgment passed by Madras High Court in case of Indian Oil Corporation Limited versus Fabtech Works and Construction and others, dated 8 November 2019. In this judgment, a very interesting question came before Honorable High Court on interpretation of price adjustment clause as to whether price adjustment clause was in effect a clause for liquidated damages where the party resorting to the same had to prove damages to seek recourse of the same. The dispute had arisen between the parties from a contract for lump sum price for supply of steel plates, fabrication, erection, and commissioning of mounted type pressure vessel for LPG storage in Tamil Nadu. The time period for completion of work under the contract was 12 months from the date of handing over of the site, which was handed over on 10 December 2007, and the work was to be completed on 9 December 2008. However, the work could not be completed within the original stipulated time because of various reasons, including delay in handing over of the site, delay in approval of designs and drawings by third-party inspection agency, changes in orientation of mounts, heavy rainfall, delay in supply of steel, etc. The parties had mutually extended the time for the contract from time to time and was finally extended up to 30th September 2009. However, the work could not be completed even in this extended period of time. According to the contractor, the same was completed on 26th December 2009, whereas as per the employer, the same was completed on 30th April 2010. Because of these delays, the employer had deducted certain amounts from the running account bills from running account bill numbers 3 to 9 dated March 2009 to September 2010. As per the employer, the deductions were made as per price adjustment clause in the contract, which entitled employer adjustment by way of discount in price at the rate of 0.5% of total contract value for each week delay in completion of work with a ceiling of 10% of total contract value. It is important to note that the clause specifically provides that the parties acknowledge that price adjustment clause is purely a provision for price adjustment and or fixation and are not to be understood or construed as a provision for liquidated damages or penalty under section 74 of Indian Contract Act or otherwise. The contractor invoked arbitration claiming deducted amount, the expenses incurred towards commissioning, and claim for loss of reputation and goodwill. Learned Arbitral Tribunal, after hearing submission of the parties, held that price adjustment clause was resorted to by employer in an unjustified manner and therefore directed the employer to return the amount deducted to the contractor. The said award was challenged by the employer IOCL before Madras High Court. The main grounds of challenge were that the contract was completed with a delay of 7 months, even after the extended period of 30th September 2009. Therefore, the employer rightly resorted to was entitled to resort to price adjustment clause in the contract. Further, the contractor had provided no claim certificate, so now contractors stopped from raising any claims. The contractor submitted that there were delays on part of IOCL, the employer. Therefore, the employer cannot resort to time extension to price adjustment clause. The contractor had no choice but to provide no claim certificate as it was prerequisite for processing of final bill by the employer. It was understanding between the parties that deductions were being made by way of imposition of LD. For the same, the contractor relied on certain emails exchanged between the parties. Employer is not entitled to deduction since it has failed to prove that loss was incurred by it due to LS delays. On the basis of submissions of the parties, the Honorable High Court formulated three issues. The first one being claim made by contractor are required to be rejected outrightly due to no claim certificate. Uh, Employer is entitled to make deductions from RA bills of the contractor. Third, whether price adjustment clause is stipulated compensation or liquidated damages clause. On the first issue, Honorable High Court held that since prior to issuance of no claim certificate, contractor had submitted final bill along with a letter requesting for release of said deductions made by the employer. Therefore, the contractor's claim could not have been rejected outrightly on basis of no claim certificate. On the second issue, on whether the employer is entitled to make deductions from RA bills of contractor, the Honorable High Court observed that the contract was extended till 30th September 2009, whereas the employer started making deductions even prior to that, that is from 28th March 2009. Therefore, the deductions were not in terms of price adjustment clause. Price adjustment clause could have been resorted to for the period after the extended completion date, that is 30th September 2009. In addition, it was admitted position between the parties that respondent was not notified about resorting to price adjustment clause. Although price adjustment clause did not specifically require issuance of notice by the employer to the contractor, however, the requirement of notification is implicit for the reason that price adjustment clause cannot be resorted to unless there's a delay on part of the contractor. Now, coming to the third issue of whether the price adjustment clause is a stipulated compensation clause or liquidated damages clause. For this, let me share the price adjustment clause in in the contract between the parties. The clause 4.4.0, the contract price shall be subject to adjustment by way of discount hereinafter specified if the units are mechanically completed or contractual work are finally completed subsequent to the date of mechanical completion, final completion specified in progress schedule. If mechanical completion of unit, final completion of works is not achieved by last date of mechanical completion of unit, final completion of the work specified in progress schedule, the owner shall be entitled to adjustment by way of discount in time price of the works and services in a sum equivalent to percent of total contract value as specified below, namely for the first week 0.5%, for 2 weeks 1%, and for 3 weeks 1.5% there. Uh, Similarly, for 20 weeks 10%. It is interesting and it is important to note that the contract specifically provides that the parties acknowledge that provision of clause 4.4.2 constitute purely a provision of price adjustment clause and it's not a liquidated damages or a clause under section 74 of the Contract Act. After After reading the price adjustment clause and section 74 of Contract Act, which provides for compensation for breach of contract where penalty or compensation is stipulated in the contract for a particular breach, the Honorable High Court observed that plain reading of Section 74 evidences that contract provides for two categories of stipulations that could operate in case of breach. The first category is a sum named in contract as the amount to be paid in case of breach, which could be described as stipulated compensation. And second category is any other stipulation by way of penalty. Thus, Section 74 does not use the term liquidated damages. It is admitted position in this case that there is no clause in respect of compensation for delay except the price adjustment clause. From the above, it is clear price adjustment clause is intended to provide compensation for loss of business due to delay in completion of work. In effect, it is stipulated compensation for delay that is attributable to the contractor. In this connection, it may further be noted that this is not an incentive-based clause whereby the contractor could receive additional payment for accelerated completion and in converse situation should provide a discount in the event of delay. On the other hand, it is a clause where compensation is provided for a particular breach. Once there is a contractual stipulation by way of compensation of delay, notwithstanding terminology or label used to describe it, and the stipulation in clause 4.4, that is price adjustment clause, it is not by way of liquidated damages or penalty. It amounts to stipulation by way of compensation as per section 74 of the contract. As stated earlier, the Honorable High Court observed that Section 74 of contract does not refer specifically to liquidated damages. It only refers to stipulation by way of compensation. Therefore, the price adjustment clause in present case would qualify as a stipulation by way of compensation. Once it is held that the price adjustment clause, it's a stipulation by way of compensation, the party resorting to the same has to prove damages to take benefit of this. The employer cannot circumvent the legal regime governing the imposition of liquidated damages merely by using a different label price adjustment in the present case. Therefore, the price adjustment clause was held to be a clause akin to liquidated damages, where the party resorting to the same had to prove damages. In my view, it was the correct view taken by Honorable High Court. Thank you.